Have you received an N12 notice? The N12 is a notice to end your tenancy because your landlord, a purchaser, or their family member requires the rental unit for personal or residential use. When your landlord gives you this written notice, it is a legal notice that could lead you to becoming evicted from your rental unit. It is important to note that an eviction notice is considered legal only when filled out completely and correctly on a landlord and tenant board form, in this case, the N12 form. Your landlord may give you an N12 notice for 2 reasons, and the reason will be indicated on the notice. Reason number 1. Your landlord wants to evict you because either they, a member of their immediate family, or a person who provides care services to their family wants to move into the unit and occupy it for at least 1 year. Reason number 2. Your landlord wants to evict you to sell the property that the rental unit is in. However, this is a legal reason for eviction only if the new buyer, the buyer's close family member, or the buyer's caregiver wants to move in. The N12 notice you receive will also indicate a termination date. The termination date your landlord sets out in this notice must be at least 60 days after they give you this notice. The termination date must also be the last day of the rental period. For example, if you pay rent on the 1st of each month, the termination date must be the last day of a month. If your tenancy is for a fixed term, the termination date cannot be earlier than the last day of the fixed term. For example, if you signed a 1-year lease, the termination date cannot be earlier than the last day of the 1-year period set out in this lease. As a part of this notice, your landlord must also agree to pay you an amount of at least 1 month's rent by the termination date in the notice, or offer you another rental unit that is acceptable to you. What you can do. You can terminate the tenancy sooner than the date set out in this notice as long as you give your landlord at least 10 days notice that you intend to move out of your rental unit. If this is your wish, you must give written notice to your landlord using a landlord and tenant board form called the N9, which is the tenant's notice to end the tenancy. If you move out of the rental unit by the termination date, your tenancy ends on the date you move out. If you disagree with what the landlord has put on the N12 notice, you don't have to move out by the termination date. Your landlord can apply to the landlord and tenant board to evict you. You will then receive a notice of hearing from the board. The board will schedule a hearing where you can explain why you disagree with the notice. Note that your landlord must apply to the landlord and tenant board for a hearing within 30 days of the termination date indicated on the N12. If they do not apply for a hearing within 30 days of the termination date, then the N12 will be void. Your landlord must also submit an affidavit or declaration of the person that intends to move into the unit. This affidavit or declaration must confirm that the person intends to move into the unit, why they need the unit, and that they intend to reside there for at least 1 year. This document should be provided to you with your notice of hearing or earlier by your landlord. You can also try to reach an agreement with your landlord before the hearing. For example, your landlord might agree to pay you more than 1 month's rent or give you more time to find a new place. If you and your landlord don't make an agreement, your case will go to an eviction hearing at the Landlord and Tenant Board. You can watch our video on the eviction process to learn more about what happens after an eviction hearing. For more information about your housing rights, visit www.WRCLS.ca. You can also contact Waterloo Region Community Legal Services at www.WRCLS.ca/web-contact. or give us a call at 519-743-0254. Check out our YouTube channel for more videos.